Our second panel is a discussion entitled A Broader View. Is it possible to win a war against entrenched terror networks while complying with modern interpretations of IHL? And for those unfamiliar, IHL is also another term for LOAC. Our guests on this panel include Captain Professor Tom Wheatley, Captain Tomer Herzig, and Professor Jeremy Rabkin. So I'm going to go through and give an introduction of each, and then each of the panelists is actually prepared about 15 minutes worth of remarks. So I will actually be handing it over to the panelists, so you'll be hearing less from me. And then once they wrap up, I may ask a few questions, and then I'm going to open it up to the audience. So without further ado, I'll do an introduction of Captain Tom Wheatley. Captain Tom Wheatley is an assistant professor in the Department of Law and Philosophy at the United States Military Academy. He teaches constitutional and military law. Before coming to USMA, Captain Wheatley was assigned to the 18th Airborne Captain Corps at Fort Liberty, North Carolina, where he most recently served as the Brigade Judge Advocate for the 16th Military Police Brigade. While at Fort Liberty, he also served as an administrative law attorney and a national security law attorney for Joint Task Force Dragon, a multinational effort falling under the USAR EUR Air Force Operations European Assured Deter and Reinforce. Before his time at Fort Liberty, Captain Wheatley was stationed at Fort Riley, Kansas, where he served as the military justice advisor to the 2nd Armored Brigade Combat Team, 1st Infantry Division, with whom he completed an operational rotation to Korea in 2020. He is a graduate of the Judge Advocate Officer Basic Course and the U.S. Army Airborne School. I was also going to say you're stationed in Kansas and you're from Kansas, but he would like us to know, a proud Kansan, Captain Wheatley is from Lawrence, Kansas. He holds a BS in Homeland Security from Embry-Riddle Aeronautical University in Daytona Beach, Florida, and was originally commissioned out of ERAU's Army ROTC program in 2014. In 2017, he earned his JD from the Antonin Scalia Law School at George Mason University in Arlington, Virginia. So that's where we are at SMEAL. His research interests include those involving the U.S. Constitution and its precepts, especially where matters of free speech, religious liberty, the law of armed conflict, public international law, and national security law are implicated. So thank you, Captain, for joining us today. Professor Jeremy Rabkin. So Jeremy Rabkin recently formerly taught as a professor of law at George Mason University. He taught courses on international law and the law of war. He holds a PhD in political science from Harvard University. And before coming to GMU in 2007, he taught for over 2 decades in the Department of Government at Cornell University. Professor Rabkin previously served on the board of directors of the U.S. Institute of Peace, so he was originally appointed by President George W. Bush in 2007 and then appointed for a second term by President Barack Obama and reconfirmed by the Senate in 2011. He also serves on the councils of academic advisors of the American Enterprise Institute and is chairman of the board of directors of the Center for Individual Rights, a public interest law firm based in Washington, D.C. His articles have appeared in major law reviews and political science journals, and his journalistic contributions in a range of magazines and newspapers, including the Washington Post and the Wall Street Journal. He is also the author of the book Law Without Nations, published by Princeton University Press. So thank you, Professor Rabkin, for joining us this evening. And last but not least, Captain Herzig. Captain Tomer Herzig is the head of the Operational Law Section in the International Law Division of the Military Advocate General's Corps in the Israeli Defense Forces. In this role, he advises the military on targeting issues and key operations, ensuring compliance with international law. Previously, he served in the Legal Advisor Unit to Judea and Samaria, in the Military Advocate General's Corps, and in the IDF Military Advocate General School, where he taught commanders about their obligations under the law of armed conflict. Captain Herzog holds an LLB and BA in governance from Reichman University. He is also a member of the Israeli Bar Association. Thank you, Captain Herzog, for staying up with us this evening, and we're looking forward to hearing from all three of you. So without further ado, why don't we start with you, Professor Captain Wheatley, if you would like to start, and then we'll go to Captain Herzig, and then we'll go to Professor Rabkin.
Thank you so much, Erielle. So good evening, ladies and gentlemen. Thank you so much for joining us this evening. And of course, thank you to George Mason CMEAL for inviting me to offer a few remarks here. And of course, thank you to the preceding panelists as well as the current panelists for agreeing to share their views on this forum. Before I continue further, of course, I'm obligated to add a disclaimer. Although I am in uniform today and using my rank and title, Please understand that nothing I say here necessarily represents the views of the United States Military Academy, the United States Army, or the U.S. government. Instead, my remarks today, please attribute them only to my own personal views, and they should be considered only insofar as they further the broader academic discussion that we're having here. So with that, let's go ahead and dive in. So the prompt today, as we already kind of talked about, was whether it's possible to win a war against entrenched terror networks while complying with modern interpretations of IHL, or as we military folks like to call it sometimes, the law of armed conflict. So broadly speaking, my answer is pretty straightforward. You rarely get this out of a lawyer. It's yes, right? But like any good answer to a legal question, important caveats apply. And for today's purposes, perhaps the most important of these caveats is that belligerents must be sure that what they are following is in fact law and not a distortion of the law. And so to illustrate my point, I'm going to use the UN Human Rights Commission's 2024 thematic report, which was released on June 19th, 2024. And this commission issued this thematic report on what it described as 6, quote, indiscriminate and disproportionate attacks during the conflict in Gaza, end quote, that occurred between October 7th, 2023 and December 2nd, 2023. So analyzing these attacks through the lenses of proportionality and distinction, the report makes the following conclusion. It says, monitoring by our office strongly indicates that the Israeli Defense Forces have systematically failed to comply with the principle of distinction, the prohibition of indiscriminate attacks, the principle of proportionality, and the principle of precautions in attack. That is a bold and even damning conclusion. But I think, as closer inspection will reveal, it's a conclusion of all bark and no bite. But before we get to why that is, we need to understand how the UN conducted its analysis in the first place. So the UN starts its analysis by defining the principle of distinction, saying, quote, parties to the conflict must distinguish between civilians and combatants and between civilian objects and military objects. So far, so good. We're all on the same page, but let's continue. Now referencing Article 57 of Additional Protocol 1, the report says Israel must do, quote, everything feasible, including the choices and methods and means of operational tactics to verify that potential targets are military and not civilian, and the presumption must be that persons and objects are civilian in cases of doubt, end quote. Moreover, an object is a military target if by its nature, location, purpose, or use makes it an effective contribution to military action, and an object's total or partial destruction, capture, or neutralization in the circumstances ruling at the time offers a definite military advantage. That's a mouthful, and as far as simple surface level sort of restatements of AP1's provisions goes, this is fairly accurate. But there's more than meets the eye here, and that starts with the obligation and the language that Israel must do, quote, everything feasible, end quote, in the context of distinction. So since AP1's exception, when I say AP1, I'm talking about Additional Protocol 1, the 1977 Additional Protocol. The precise meaning of the word feasible has been the subject of a fair amount of disagreement and controversy. So under the American view, a state has to exercise due diligence, but it's not required to do, quote, everything possible. Moreover, any feasibility analysis is always conducted and judged through an ex ante perspective rather than an ex post perspective, meaning that commanders are judged based on what they knew or reasonably should have known at the time of a decision, not by what comes to light after the fact. Okay, and this is critical. So some of the world's most powerful militaries define feasible in this context to mean that which is, quote, practicable or practically possible, taking into account all circumstances ruling at the time, including humanitarian and military considerations. This is a little bit different. This definition, which emphasizes the military considerations more so, or perhaps not more so, but alongside humanitarian considerations, has been adopted by the United States, the United Kingdom, Canada, Germany, and the Netherlands. So a lot of major world powers have adopted this definition, and it's also used in other sources of law of armed conflict, CCW protocols and whatnot. So not everyone agrees with this take, however. The ICRC, the International Committee of the Red Cross, for example, they believe that considering factors relevant to the success of military operations, really makes Article 57 much too permissive, fearing that by invoking the success of military operations as part of the analysis, you might end up neglecting the humanitarian obligations prescribed in Article 47. Yet the UN report doesn't make any kind of mention of this disparity. It does, however, cite the ICRC's commentary generously, and that indicates a reliance on a view of the law that is apparently far more restrictive than what state practice actually reflects. Moreover, the UN report makes no attempts to understand what information Israel's commanders knew or reasonably should have known at the time of each strike. And this is kind of the crux of the error in this analysis. It provides, at best, a perfunctory battle damage assessment, relying on casualty figures, no less, from the Ministry of Health, which is run by Hamas. It doesn't distinguish between military and civilian deaths. It concludes its analysis without ever really knowing the contextual interests the contextual military interests at play at the time of each strike. And this reflects sort of a belief that is increasingly common but categorically wrong as a matter of law. And that is that an attack's lawfulness can be determined solely by the number of casualties it produces. That's just simply not the case. The report attempts to sort of divest itself of responsibility for this kind of shoddy legal analysis by blaming Israel's decision not to publish the nature of the military objectives in some of these earlier attacks, even going so far as to paint Israel's silence as further evidence of culpability. Instinctively, lawyers will they'll bristle at this sort of insinuation that a party's silence is somehow evidence of guilt. So let's be clear. There is nothing in the law of armed conflict that obligates a state to publicly justify its targeting decisions. And indeed, operational security, including such like things like the intelligence sources and methods, may demand that a state actually not do so. There are very good reasons for not disclosing why something was made a target. Nevertheless, the UN report marches onward, and it concludes that Israel took a, quote, expansive approach to targeting, apparently considering members of de facto civilian administration and Hamas political structures not directly participating in hostilities, as well as civilian objects belonging to de facto authorities as legitimate targets, in violation of the principle of distinction, end quote. Israel has, moreover, says the report, has conducted 10,000 airstrikes in a course of about 3 months, which, according to the report, raised concerns regarding the identification of targets. So the skew on this is nothing short of disorienting. First, we need to get one thing very straight. The number of strikes in a given period has nothing to do with whether or not those strikes comported with the law of armed conflict. This is just sensationalism at work. And second, we have to be very clear about what the rule at issue. Civilians generally may not be, or not generally, civilians cannot be made the object of attack unless and for such time as they take part in hostilities. Importantly, neither the Geneva Conventions or the additional protocols defines precisely what direct participation in hostilities. And indeed, a term like feasible that we talked about earlier engenders substantial disagreement. Under the American view, direct participation in hostilities extends beyond just engaging in combat, and it can include acts that are integral parts of combat operations or that effectively and substantially contribute to an adversary's ability to conduct or sustain combat operations. So let me help you understand what exactly that means. Here's from the Department of Defense Law of War Manual, things that are generally considered not to be participation in hostilities. Expressing mere sympathy or moral support for a cause, buying war bonds, civilian police officers enforcing the domestic criminal code against common criminals, independent journalism, public advocacy, right? In contrast, here's what the UN, according to its own citation, said counted as de facto civilians and civilian objects: an underground tunnel and 2 operational command centers used by Hamas, 2 terror compounds used for training, manufacturing, and storing weapons, 2 bank branches that facilitated financial transactions for Hamas, a Hamas commander's headquarters, a weapons storage facility, an Islamic Jihad operational command center, and a mosque used as an Islamic Jihad weapons storage facility and base. The UN is saying these are de facto civilians and civilian objects. Going further, the UN report fails to consider for how long a civilian who directly participates in hostilities can be made the object of an attack. So once you've engaged in direct participation in hostilities and then perhaps cease, let's say, shooting a rifle, how long do you remain a targetable? Can you be made the object of an attack? This is a notoriously gray area and spurs considerable disagreement among LOAC scholars. So in the American view, there is no revolving door of protection. It's not like you can pick up a rifle, participate in combat, and put it down and then be protected as a civilian again. In the United States' view, Nothing less than permanent cessation of hostilities, evidenced by clear renunciation and willingness to cease hostilities, will work. The report also completely neglects the theory that persons belonging to hostile non-state armed groups may fall outside the protection granted by civilian status if the group they exist to belongs, or excuse me, if the group they belong to exists solely for the purpose of engaging hostilities. We know by the Hamas founding charter that its existence is to destroy Israel. The entire organization is defined by this purpose of hostility. But anyways, none of this is law. This is all to say that none of this is law. It's one particular take on the law. Furthermore, it's quite ludicrous, I think, to say that a commander could accurately sort of conduct this painstaking of a legal analysis under extreme time pressure and with limited information. So simply put, it just doesn't reflect a reality. And moreover, it completely ignores Hamas's endemic use of civilians as human shields. And importantly, under the American view, when an enemy uses civilians as human shields, as long as the attacking force has taken these civilians into account in their proportionality analysis and taken feasible precautions to mitigate incidental harm to civilians, and this is directly from the DoD Law of War Manual, that the party that employs civilians as human shields, quote, assumes responsibility for their injury. We have a major world power, state actor interpreting the law of war to say that as long as the attacking force has done its homework and is making its best efforts, good faith efforts to comply with the law of armed conflict as it relates to proportionality and feasible precautions, any incidental harm that comes to civilians used as human shields falls on the party using them as human shields. But anyways, we'll move on to the proportionality portion as well. We're running a little bit out of time here. So similar to the distinction discussion, the UN report has several major flaws in its proportionality analysis. Some of these are repeat errors from before, right? You have commanders failing to consider their perspective of commanders, ignorance of the operational context and military advantage to be gained from the attack, drawing unsupported conclusions of law based on incomplete information, relying on data involving harm to civilians to reach broad conclusions, just errors in legal reasoning. But perhaps the apex of the UN report is its emphasis on the type of bombs Israel uses in each strike, which the report says it emphasizes how Israel used large and heavy munitions in densely populated areas and offers this as further evidence that Israel was acting disproportionately and without regard to distinction, moreover. But had the UN's authors, I think, been less interested in, I said the UN report's authors, been less interested in rushing to judgment, perhaps they would have taken the time to crack open a targeting manual. And fortunately, some of my uniformed colleagues did just that back in September and wrote about it in Articles of War. And full disclosure, I'm an editor of that blog. And they clarified that a bomb's weight and the size of its warhead do not directly correlate to anticipated civilian harm, which for LOAC purposes is what's mostly relevant. I should say legally most relevant. Even a passing familiarity with targeting fundamentals would have revealed a multitude of factors that influence a bomb's lethality, such as delayed fusing, variable timing, shielding tactics, delivery heading restrictions, and even aim point offset. All of these are very complicated analyses that can change the outcome of a certain strike. In the right combination, it might be that these factors actually yield instances where using a larger bomb will actually lessen the degree of incidental civilian harm. Yet the UN report sort of just galumps past all of this and settles on the conclusion that I'll paraphrase as big bomb bad. That's its totality there. So moving on, I'm not going to belabor the point here. There's a lot of problems here. So the report's broader problem is that there's a frequent reliance on something other than law on the topic of proportionality, other than its reference to the general rule of proportionality, which is that an attack is not proportional when it may be expected to cause incidental loss of life, injury to civilians, damage to civilian objects, or a combination of thereof that would be excessive in relation to the concrete and direct military advantage. Anticipated, the report doesn't really cite law, but instead cites more so the ICRC's commentary on the Geneva Conventions. And often it's in ways that's misleading to the casual observer. So for example, take the expansive warning in the report that IHL/LOAC doesn't provide any justification for attacks which cause extensive civilian losses and damages, and that incidental losses and damages should never be extensive. That's not true. That's not law. If you accept that the Geneva Conventions reflect customary international law, you don't have to look any further than Article 147 of the Fourth Geneva Convention to prove it. And it says extensive destruction and appropriation of property not justified by military necessity and carried out unlawfully and wantonly. Excuse me. Extensive destruction and appropriation of property not justified by military necessity and carried out unlawfully and wantonly. It prohibits that. Now, to be clear, I am not saying that any destruction is lawful as long as it doesn't amount to wanton destruction. That's not the law either. But it does mean that there are, in fact, circumstances where extensive destruction may be lawful. And this is captured as well in the ICC statute, right? The report admonishes Israel as having committed a war crime under Article 8 of the ICC statute. But here's what that statute actually prohibits. It prohibits intentionally launching an attack in the knowledge that such attack will cause incidental loss of life or injury to civilians or damage to civilian objects or widespread long-term and severe damage to the natural environment, which would clearly, this is the important part, which would clearly be excessive in relation to the concrete and direct overall military advantage anticipated. So in fact, it does seem that IHL provides justification for attacks, even those which can cause extensive civilian losses and damage. And it happens to nest directly with the universal rule of proportionality. It's excessive when it outweighs the concrete and direct overall military advantage to be anticipated. So where does this leave us? So how can you spot these sort of low-act distortions? It's possible to win a war against an entrenched terror network and while complying with low-act, but I'm doubtful it's possible to win a war when you're complying with low-act distortions. So how do you spot low-act distortions? Well, first, understand that commentary of the law is not law. The ICRC's commentary on the law of armed conflict, like many other commentaries, is insightful, it's thought-provoking, and it's helpful in driving discussion and analysis. It's not, however, the law. States are in a far better position to say what the law is, and because states are the only entities that possess the power to actually make international law, both in the form of treaties and through state practice. They're also the ones with skin in the game. And they have the best information out of any of the interested parties in a conflict, especially when it comes to understanding an anticipated military advantage. But don't just take my word for it. Look at Article 38 of the ICJ statute. It points to 4 different sources of law, including international conventions, international customs, general principles recognized by civilized nations. And then all the way at number 4, do we see judicial decisions and the teachings of the most highly qualified publicists and various matters as subsidiary means for the determination of the rules of war. So even if you're consulting commentaries, you're consulting the 4th best source of law, so to speak. And it's only then a subsidiary to inform. Second cardinal rule in spotting low-act distortion: state aspirations are not the law. So the United States recently released its long-awaited Civilian Harm Mitigation and Response Action Plan, also called CHIMRAP for short. And it's been billed as this sort of watershed initiative that envisions a series of major actions the DoD will implement to mitigate and respond to civilian harm. It's a promising initiative that takes the lessons of the last 20 years in counterinsurgency to improve upon the DoD's ability to mitigate incidental harm to civilians and civilian objects. In large part, the DoD has been lauded for its efforts in this respect, but as Lieutenant General retired Charles Peedy, the 40th Judge Advocate General of the Army, recently emphasized in another Articles of War post, as praiseworthy as CHIMRAP is policy. It's not law. It's a goal. It doesn't create a new legal standard, which in turn means that any failure to meet these self-prescribed standards does not itself amount to a violation of the law of war. And there may be instances on the horizon where operational realities may demand a swift departure or modification from CHIMRAP's requirements. Third, no single state decides what LOAC is, right? Just because one state does one thing and another state does another doesn't mean that that one state carries more weight than another one. And in fact, when the When the ICRC released a 2006 report describing what is customary international law, one of the objections the United States lodged was that it was taking into consideration, or perhaps giving too much weight, the opinions of states that haven't really been engaged in serious armed conflict in a long time over the states that have been engaged in profoundly serious armed conflict. The states that are regularly engaged in armed conflict are going to have a better understanding of what's realistic in LOAC and what's not. And then fourth and finally, watch out for bad lawyering. Let the UN report be Exhibit A of this. Facts come first, then comes analysis, then comes conclusion. It's the fundamentals of every legal analysis. There's no such thing as a presumption of a LOAC violation just because civilians, even a lot of civilians, have been killed. Nor is a state required to publicly disclose the military advantage it hopes to gain by conducting an attack. Nor is the state's decision not to point to decisions not to report these justifications publicly suggest culpability. Similarly, if you can't articulate what feasible precautions a state took or did not take to prevent incidental harm to civilians, which might, by the way, include times when states choose not to act, you cannot conclude whether a strike was lawful. So to wrap this up, we have a saying here at West Point and in the Army more broadly, winning matters. If it's left unchecked, a fake law of war, a LOAC distortion, I prefer a fake law of war, will seriously impair the United States' ability to fight and win our nation's wars. The threat is especially dangerous as the prospect of peer-to-peer large-scale combat operations return. And we're talking about the kind of armed conflict where casualty reports come by the thousands, where commanders have seconds, not minutes, to react, and where legal advisors might be detached and few and far between, spread across an entire theater of combat rather than co-located in a command center. In such cases, American commanders can't allow themselves to be cowed by these contrived rules of war or pedantic legal sophistry, unsure of their authority to leverage the full and truly devastating extent of their combat power. Commanders who understand their duty won't let this happen, to be clear. Commanders who understand their duty won't let this happen. Which brings me to what I think what is actually most imperiled by a distorted LOAC. And I think, Erielle, you brought this up in the previous panel, and that's LOAC itself. So last year, the Geneva Conventions turned 75. These sorts of documents were drafted by people who knew intimately the extremes of war's horrors and ratified by those who believe that if there's a way to limit war's misery, however small, we should. Their aim was noble and it remained so. But they did not seek to remake the nature of war. Winning still matters. States have no obligation to follow an interpretation of the law that denies them their most fundamental, inalienable rights as peoples and as nations. The American Declaration of Independence, tragically, doesn't get as much mileage in the international sphere, but it still rings true when a long train of abuses and usurpations evinces a design to reduce them under absolute despotism. It is the people's right, it is their duty to throw off such forms of law. So we are dangerously close. If LOAC wants to remain relevant and realize its good and noble purpose, it must guard against this sort of destruction by distortion. If we're to have a prayer at restraining the human capacity for terribleness in times of war, while still enjoying the humanitarian ends of war, rigor has to be our guide, along with fidelity to legal norms, both written and unwritten. And with that, thank you.
Thank you for your comments, Captain Wheatley. They were very informative. I actually think that it may be good for me to ask, like, one or two follow-up questions from each panelist while they're on the topic, so it's fresh in your mind, and then we'll
Sure.
jump to the next panelist. So, the first question that comes to mind just from listening to you speak is that it seems to me that LOAC, we've given LOAC a tough break, but it seems to me that we've been tough on the distortion of LOAC, not LOAC itself. What you've described is that you want a world with LOAC. I mean, we want a world with a law of armed conflict because there's some element of honor, and it keeps, as much
Yeah.
as possible, it keeps casualties confined or outside of civilian areas, or it tries to limit the amount of civilian deaths. Would you agree with that? That's what that LOAC itself is honorable. It's the distortion that perhaps we find most objectionable.
Yeah, we should not see LOAC as this sort of loopy experiment post World War II. We have to remember that the Geneva Conventions, and for that matter the UN, was created by people who defeated the Nazis. They understood the requirements of war, right? So what we have to guard against is not so much the idea that we put restraints on war. We have to do that, right? And the Nuremberg tribunals, for example, were caught in a position where there wasn't really a clear code of law to charge people. Establishing some kind of positive law to do that helps anchor it to something, right? Going forward.
Right.
Um, and to have these rules is really useful. It's a noble purpose, but we have to guard against those kinds of distortions that will ultimately destroy these rules.
Okay, and my last question for you is, how do you think our historical compliance with LOAC, Israel's historical compliance with LOAC, has perhaps landed us here in some ways in sort of a weird, I don't know what I guess the catch-22 would be the right term, but I think
Mhm.
yes, how has our historical compliance gotten us here?
Yeah, well, the previous panel made an interesting comment on this that it's their sort of modus operandi to use our good faith compliance with LOAC against us, right? And so I don't think that's at all that necessitates a departure from complying
Mhm.
with LOAC. But we have to recognize the operational environment we're working in here, and that's in my view when we have to be particularly on guard because at this point it's lawfare. They're taking positive law and they're distorting it for their own ends. The response to this is not to deviate from what we know the law requires because we have followed it. It's to make sure that the world knows and we communicate clearly that what these people are putting forward is not realistic. It's not what we actually do
Mhm.
in real life, and it's purely to gain an advantage.
And you would say that you made a point about how it seems to it limits the maneuverability of commanders in war, but it also seems as if this destruction or the bastardization of LOAC actually threatens soldier safety and civilian safety as well.
Yeah, absolutely. It's, when I say that the greatest, the thing most imperiled by these distortions is LOAC itself, juxtaposition that next to my other comment, which is that ultimately, if commanders are finding that this LOAC stuff is just kind of like a thorn in their side that their enemy doesn't follow, they're going to lose patience with it, especially if it interferes with their ability to do what their oath requires them to do, which is win.
Mhm.
And so if LOAC wants to maintain its usefulness, it can't capitulate to these bad faith actors.
Great. Well, thank you for your comments, Captain Wheatley. They were very informative. And
My
now we
pleasure.
finally turn to our guest, who I guess the time difference now, it's 3:30 a.m. Captain Herzig, please feel free to begin.
Hi, thank you for having me. Very honored. And yes, so it's just over 24 hours since I was woken up by the siren of a Houthi ballistic missile. So I'm used to these hours. Two preliminary comments. I am wearing uniform because I was authorized to speak on behalf of the IDF. So I'm going to try and represent some official IDF positions. I hope it won't limit my ability to answer questions. And the second one is, Tom, I'm so happy that you introduced the UNOHCHR report because I wrote the response, the MFA initial response for it.
Bravo.
Um, yeah. So I could recognize some of the things you said, and I'm gonna try and go on the same line that Tom paved for me and give it perhaps a bit more color on how the IDF applies what Tom just introduced. I I think that the topic of our panel represents two major challenges for Western law-abiding armies. The first is the challenge of the asymmetric warfare and asymmetry not in the size or strength of force and military size, asymmetry in the legal sense, meaning that one side is committed to the rule of law and following LOAC, and the other side exploits that commitment in order to delegitimize the committed side. And the second challenge, which is my main focus in the following minutes, is what you named in the topic modern interpretations, and I prefer to name it modern misconceptions, and Tom named it distortions, and especially on how we examine compliance with the law today. So I'm going to try and demonstrate using three examples how the IDF applies the law and how and to show through that the misconceptions of what the law is and how it's analyzed. I'll start with what we usually see in the media when looking at wars from afar. I think that what catches me the most, and I'm sure many of the audience, is actually hard images of ruin and wreckage and destruction from of infrastructure and the tragic outcomes of war in urban environment. That also triggers, a very human response of, deep empathy and like a heart-wrenching feeling. And the problem is that many times this very human response is then translated into criticism of the legality of actions. And I see it all the time regarding the war in Gaza. People see really heartbreaking images of ruin in certain neighborhoods and assume, based on the image they see, that this cannot have been legal. This is indiscriminate damage to the urban environment. Now, this represents a result-oriented approach to appraisal compliance with the law and of misconception of what distinction and the rule of distinction is and how it's applied by states. Going quickly, what distinction means, if just as to level the ground for everyone. So, in the law of armed conflicts, distinction means that attacks can only be directed at military objects and not at civilian objects. Article 52.2 to the first additional protocol of the Geneva Convention, which, by the way, Israel is not a party to the protocol, but we do see it as to reflect customary international law, those specific articles. So that defines a military object as any object that by nature, location, purpose, or use makes an effective contribution to military action and whose total or partial destruction, capture, neutralization offers a definite military advantage. So IDF directives define military target using the exact same wording as the protocol. Interesting enough, we have the same definition of distinction and military targets. Tom, correctly if I'm wrong, in the manuals, law manuals of the US, Australia, New Zealand, Denmark, and the list goes on. And I'd say that in some cases, the IDF directives are even more restrictive when it comes to, for example, war-sustaining targets. So what does this tell us? That according to Western law-abiding militaries, in order to assess the compliance of an attack with the rule of distinction, one must ask whether the attack was directed towards a military target and to ask what was the target struck. The problem with asymmetrical wars against terror armies like Hamas and Hezbollah is that they intentionally assimilate their assets in ostensibly civilian objects. In the case of Hamas, I remind you that they have been in control of the Gaza Strip for the past 16 years, spending all the time and resources deeply embedding military assets throughout Gaza. So you have militants that use their homes as frontal fighting positions. Private homes are booby-trapped or used as weapons cache. Hospitals systematically used for operations and to shield significant assets. UN facilities, including schools, are used as command and control centers and firing posts. And this is an organization that started the war with around 40,000 operatives and very, very few formal military bases. So just imagine how spread out they are. Another important aspect is, of course, the tunnel underground infrastructure system, a very critical infrastructure for Hamas operations, hundreds of kilometers dug throughout Gaza under hospitals, schools, each tunnel with multiple entry and exit points into different buildings, which have been booby-trapped to set up for ambushes. That's the reality of Gaza. Hamas transformed much of the civilian environment for its military use. And to completely remove Hamas military capabilities, there is no choice but to undertake massive operations. Unfortunately, we have to fight where the enemy is, not where we wish it was. And this requires striking many thousands of targets, often with significant firepower, because they have so deeply embedded their assets in terrain, including deep underground. I'm going to share a quick slide just to show you an example of how this looks like. Can everyone see the slide I'm sharing? This is just northern Gaza, and this is only things, targets that I could declassify to show this forum. Imagine um, many more dots which represent targets, and imagine it throughout the whole of the Gaza Strip. And again, this is only intel-based targets that I could declassify. I'm going to stop the sharing now, because targets can also be discovered during ground operations and ground maneuver, and when the ground forces see an enemy moving in real time and going into buildings and booby trapping new buildings. So this is like an ongoing thing that emerges all the time. So legal criticism, which is based on result without factual understanding of the nature of the conflict, is legally flawed. As Tom said, the law is derived from facts. One cannot assume in compliance with the law only upon results, even if the results are tragic. So this is to go with distinction. Going further to proportionality, in many instances, strikes regrettably result in casualties. It's regulated in the principle of proportionality in IHL, which requires that the expected loss of civilian life, injury to civilian objects, or combination thereof will not be excessive in relation to the anticipated direct and concrete military advantage. So the UN report that Tom mentioned, it gives 6 examples of strikes that IDF did, and in one of them, they say the following thing. The following thing, sorry. They describe a strike conducted in November 2023 in which we struck Al-Qassam commander. Al-Qassam is Hamas military wing, and killed 60 civilians. And they claim that we weighed the 60 civilians against that one Al-Qassam commander, whether with or without combatants. I'm not sure what that means, but that's what they write. And they claim that the strike was disproportionate. Now, this example demonstrates two main flaws of how compliance to the law is assessed. The flaw of relying on benefit of hindsight and assessing by result in similar manner to what I discussed in relation to distinction, and the flaw of shifting the burden of proof in terms of numbers and intel. So proportionality is a conduct-based test, not a result-based test. It's considered on a case-by-case basis, generally concerning the particular circumstances of each individual strike, considering all the relevant information reasonably available to the decision maker, which is the commander, at the time of the strike, never in hindsight. For each and every strike, one must ask what was the military advantage that the commander anticipated. This can be perhaps to take out rocket launching capabilities, or maybe to eliminate Hamas militants and commanders, or to disrupt Hamas command and control, or perhaps to deny Hamas of its infrastructure, or all of the above together, right? All of these tactical advantages are, of course, informed but not superseded by a larger goal of rescuing our hostages and destroying Hamas's military capabilities. Now, this does not mean, as some have suggested, that we attach to each and every strike the overall advantage of dismantling Hamas and rescuing all of our hostages, which are held unlawfully and are subject to inhumane treatment, including today. It simply means that the military value of taking out certain capabilities are understood in light of the unacceptable security threat posed by Hamas as seen on October 7. Taking out enemy forces that are mere minutes away from your civilian centers holds greater military significance than striking them when they are thousands of miles away from your home front. This reflects a simple and uncontested matter. Proportionality must always be assessed in the relevant context, quote unquote, in the circumstances ruling at the time. That's the language of the protocol. I'll give some more color to this. Going back to the example of the commander and his combatants. Well, since each militant contributes independently to the military action of Hamas, each militant eliminated holds a separate military advantage for the IDF. Naturally, eliminating a commander together with his subordinates, as well as other military infrastructure, holds an even greater military advantage because it holds the potential of degrading Hamas capabilities to remain organized and fight in a certain area of operation. This advantage can be even greater if our troops are maneuvering nearby, thus the advantage of eliminating an immediate threat to our forces. Now, some view this so-called force protection as irrelevant factor, claiming that this approach favors lives of combatants at the expense of civilians. But what they overlook is that preserving military forces is key to mission success. The forces on the ground need to carry out an important mission. If they fail, the mission fails. So force preservation, as opposed to force protection, is an important factor in proportionality assessment during ground operations. Now, in terms of foreseeability of civilian harm, reasonably foreseeable consequences need to be taken into consideration. Without, as Tom mentioned, without knowing what commanders anticipated, after considering all relevant information available at the time, it's impossible to reach a conclusion on proportionality. I'll give some examples. What if, despite all efforts put into planning process of the strike, there was no information about rockets at the site, which caused by secondary explosions further loss of life, right? Or even after analyzing all available intel, there was no expectation for the presence of uninvolved civilians. These would not deem the strike disproportionate. And sometimes these decisions, whether to strike or not, need to be taken quickly while the fog of war is still at its thickest. And when the price of not taking action is also very, very high. So this is one of the reasons why result-oriented analysis of proportionality in hindsight is misguided and does not represent the law. It's a misconception of IHL. And of course, the second flaw that compounds on this matter is the reports on civilian casualties coming out of Gaza, which are unreliable. And I think I won't go more into this, but a new report by the Henry Jackson Society does an extremely good job at showing this and proving it. The third example that I wanted to use to demonstrate this point is about the choice of munitions. So one very prominent criticism, which was mentioned in the OHCHR report, was about the using of 2,000-pound bombs, the Mark 84, which is one of the most used bombs in this war. And they claim that it's indiscriminate and disproportionate by nature, the use of this bomb, because of the effect it causes the surrounding upon impact. It said that according to obligations under IHL to take all feasible precautions to protect civilians, there is an obligation to use smaller munitions. Now, this legal criticism, which is echoed by media, law experts, and of course UN organs, basically outlaws this type of munitions in the urban environment. It misses some key understandings about what precaution and the obligation of precaution is. Well, the law's emphasis is on what's feasible. Feasible precaution, as Captain Wheatley said, it's what's practicable and practically possible to take into account in the circumstances ruling at the time. In the process of targeting, a professional targeting process includes adjusting size of munitions, payloads to the target in accordance with the desired military objective. When assessing feasibility, it's important to understand that some military objectives cannot be achieved using smaller munitions. Heavier munitions must be used in order to destroy the target. For certain targets, such as those made from concrete, stone, brick, targets which are underground, a 2,000-pound bomb is the only munition that can achieve the military objective. This can be learned also from military manuals and post-operation reports by the United States and the UK, which actually recommend using this type of munition to penetrate reinforced targets. And in the context of the Gaza war, of course, many targets are from brick, concrete, stone, and underground. So it's the only feasible munition. To conclude, I think that Captain Wheatley and I have the same conclusion. Yes, of course, it's possible to win a war with modern interpretations of IHL, because the modern interpretation of IHL is the one of states who practice IHL and not the misconceptions of IHL. I think that according to the law as it is today, there is no military objective on the battlefield that IHL prevents the reasonable commander from achieving, even if there are certain conditions to achieve it. That's my statement for then, and I'm happy to take questions.
Great. Well, thank you, Captain Herzig. You know, a few questions came to mind as listening to you and also coming into this presentation. I was interested in, and I don't know if you're able to answer this, and so, you know, please say that you can or can't. It's no skin off my back. How is the decision to strike made in the IDF? So I know in the U.S. military, and Captain Wheatley can talk more about this as well at some point. You know, there's a strenuous process that the U.S. military goes through before they engage in a strike. A good example, they might actually set up cameras around a particular location to see when civilians are in the area or not in the area and figure out, you know, when it may be less populated. I know that there will be several phone calls with legal authorities, perhaps in the IDF like yourself, to actually discuss sort of this balancing test that we've been talking about this evening. So to the extent that you're able to give us a bit of a window into that, I think that would be very interesting.
Yes, of course. Our targeting process is comprised of several steps involving expertise from all relevant military professions. Um, for simplicity's sake, I'll just say the following. We have teams which comprise of legal, myself and my officers, weaponeering experts, the intel people, um, who make up as a team find the targets. Most of them are intel based. And everything is, of course, done according to strict IDF directives, as I mentioned, which describe and define what a target is and um, what military objectives can be achieved. And then there's, you know, a certain approval process and um, relating to the complexity of the target and perhaps the number of civilian casualties anticipated, and the approval process will go through higher ranks of approval. Um, and it's quite a rigorous process, but that it's for it can be very quick because everyone's working 24/7 now in the war, but it's quite a rigorous process in terms of approvals. That is for intel-based targets. Of course, you also have dynamic targeting, which is what happens during ground operations when ground troops just, you know, see something and report it directly, and they have a close connection with the Air Force and direct the strike the way they see it. And then again, everything has decisions that you need to make in seconds or minutes because you have a threat, an imminent threat, in front of you.
Thank you. And this is one last question from me with regards. So this is a subject that hadn't been brought up yet, but you brought it to the forefront, is the question of when we're engaging in this proportionality analysis, what numbers are we relying on? And so you brought up an interesting point that, you know, for instance, the Gaza Ministry of Health has, you know, produces numbers that are perhaps inaccurate, to put it kindly. And how do these inaccurate numbers coming out of Gaza, how do you folks deal with it in the IDF in terms of when you're going out into the public and saying, you know, we engaged in this strike and this is what happened, you know, how are you guys able to combat the misinformation that's coming out of Gaza? So a lot of times we end up finding out that actually, you know, the civilian to terrorist ratio is actually quite low, and it's one of the most impressive in the world. And so, my question to you is, how do you guys combat the misinformation coming out of Gaza, especially with regards to the proportionality analysis and how it comes into play under LOAC?
It's very hard to combat misinformation from an organization that doesn't mind lying. You know, an
Mm,
organization who doesn't mind massacring and burning alive and taking civilians as hostages obviously doesn't care about the truth. So
yeah,
it's hard in that, and we do care about the truth, and we won't put out numbers that we're not um, sure of. That's, I think, one of the reasons why the IDF had not put its own official numbers to this day, because it's very, very, very hard to assess um, results of strikes.
yeah,
And in this intensity of war, it's even harder. I think John Spencer wrote about it quite nicely. And in terms of proportionality, so the proportionality is something that we do before the strike and not after. So
right,
even if the Hamas will publish numbers which for us are like off the charts and we never expected it, we're sure with the proportionality assessment that we did and the assessment that
right,
we made before. When reports do show extreme numbers that we like surprise us, then we take it to our assessment mechanisms to see if perhaps something was wrong with the process. So we're all about whether the process was correct and whether the process was fine. And if not, then we have tools to handle um, processes that weren't as the directives instruct.
understood. So it's a good reminder that when we're engaging the proportionality analysis, it is conduct-based and not results-based. And I think that also, to your point, when you first started, that gets lost in the conversation far too frequently. And it makes it hard to actually, have a real substantive and genuine determination of whether a nation state is complying with LOAC.
I
Thank you.
actually have a very good example of a strike that that could like go into that
Yeah,
specific
sure.
question. There was a strike made in the area of Rafah against two very high-ranking terrorists. Very, very precise. Actually, we used a small munition there, and we used surveillance ahead to see that there's not no civilians next to them. But the result of the strike was that some tents and shelters a couple of 100 meters away, a fire broke out and it caused the tragic death of several civilians. Reports go between 40 and 70. That is a very good example of a strike that we would not deem that disproportionate because it's about the planning ahead, and the planning ahead did we didn't assume any civilian casualties for that civilian specific strike. What we did do is after we got the reports of the high number of casualties, we transferred that incident to our fact-finding and assessment mechanism, which is a mechanism meant to deal with would say irregular things that happen during the course of war, and to assess whether there was perhaps suspicion for criminal misconduct. At this case, there was no suspicion for criminal misconduct because the process was as it was supposed to be, and this is one of the terrible, terrible, terrible outcomes of war.
Well, thank you for sharing that, Captain Herzig. Very interesting. And so we will finish up now with our last speaker, Professor Rabkin, who's been very patient. And I'll remind the audience that thank you for submitting your questions. You can continue to do so. I'm going to open it up for audience questions once Professor Rabkin finishes. So without further ado, uh, Professor Rabkin, you have the stage, the floor.
Well, let me start by apologizing. Every few minutes, I got this little notice that my internet connection is unstable, but I don't know what to do about that. So if my frame freezes, just try and bear with me, or you can play music for a minute, but it has always unfrozen after a bit. If you are a military lawyer, you're under a lot of pressure to say, this is the law, here is the right answer, and the people that I'm advising in the military can rely on it. And that is their job, and I don't want to take anything away from them. I really admire them because it's very, very difficult. For the rest of us, really my remarks are just to put this in perspective. It's very hard to make this law very clear and precise. I just want to give you some background on this. People keep talking about the law of armed conflict. And often they will say, like, oh, for centuries, we've always had the law of armed conflict. It's really changed a lot over time, and there are really important major continuing disagreements about it. It's been mentioned a couple of times. There's the source that's most often looked at is Additional Protocol 1 to the Geneva Conventions, which they completed the drafting of that in 1977. That changed the standards. It tried to tighten the standards. It tried to say, like, we have to avoid hardships of war more than we did previously. The Red Cross commentary says, well, these are really traditional standards, which go back a very long way. It's just that during the First and Second World War, the major states got so angry at each other that they disregarded all the rules. So if you remember, like, yeah, wait, we used to bomb these German cities and Japanese cities, and we didn't say it was against the law of war. As a matter of fact, we not only did not say it at the time, we didn't say it in military manuals published 30 years later, American military manuals. It's a change in AP1 to put various restrictions on things. So let me just mention a few of them and just show you, forget about the world wars of the 20th century, just like a look at major military campaigns in earlier times. Starvation. It's totally against the law of war to starve people. No, it isn't. Oh, well, it didn't used to be. I mean, Arielle's nodding because she mentioned siege and was trying to say, like, were you allowed to have a siege but not to hurt civilians? No, no, no. The purpose was to put pressure on the military garrison by preventing even the civilians from getting the food. So they would say, we have to surrender. Famous case, the siege of Vicksburg during the American Civil War. We didn't say afterwards, General Grant, you're a war criminal. We said, you are great. President Lincoln said, you are great. You should now be in charge of all the armies because you did so well. The first sort of codified overview of the law of armed conflict, which is generally taken to be this, is the code issued for the Union Army during the Civil War. Francis Lieber, who wrote that, thought sieges were fine. This is a very traditional kind of thing to do. Even at the end of the Second World War, we put German generals on trial regarding atrocities on the Eastern Front. And one of the things that there was a question about, like, you starved people in Leningrad, and an American military tribunal said, well, that is the law of war. You're allowed to do that. That is done. The Germans had done it to Paris in 1871 during the siege of Paris. No one complained about that. That was just accepted. I'm not saying we should have that standard today. I'm just saying this idea that you can't starve civilians, it was not the traditional idea. Bombardment of civilian property. What they also did at Vicksburg, of course, was they lobbed shells into this place, and civilians had to dig into the ground. This is what the Germans did outside of Paris in 1871. The Hague Convention on Naval Bombardment from 1907 says, when you need supplies, you can go to an enemy port and say you need to provide us supplies, and if they refuse, you can bombard them, because of course that's an obvious way of pressuring them, right? Now we want to restrain this more. Immunities, the Hague Convention from 1907 admonishes that you should not bombard hospitals, schools, places of worship, historic monuments. But the reason they give that list is they don't have this concern about, like, don't bombard civilian property. They take it for granted that if you're bombarding a city, you're going to hit some civilian property, and it's part of what war is. AP1 has a much, much broader and more dogmatic exclusion of not only civilians, but civilian property from attacks. Now, I'm not challenging any of those and saying we need to go back to the good old days and starve people. But let's start with we're trying to have a more restrictive version of this. And the second thing I want to just briefly emphasize is we've changed our understanding of what this is. If you go back to the Hague Convention, it says in the preamble, Hague Convention on the Law and Custom of War from 1907, these provisions have been inspired by the desire to diminish the evils of war as far as military requirements permit. So the emphasis was first military requirements, and then if it's not necessary to your military success, then you should be humanitarian. We have now started to talk about humanitarian law. Even that term, humanitarian law, was to make you associate it with human rights. In fact, the origin of AP1 is that the UN organized a conference in 1968 to celebrate the 20th anniversary of the Universal Declaration of Human Rights. And a lot of participants said, we're talking about human rights, but America is bombing civilians in North Vietnam. And it's using chemical weapons, and it's using gas, and it's committing terrible atrocities. And human rights, there should be a human rights convention to protect against this, to stop this. That came back to the General Assembly. There were various motions. The UN should have a new human rights convention. They had just finished the original human rights conventions on civil and political rights and economic and social rights. So now we're going to have new rights of people in warfare. The Western power said, let's move this to Geneva. Let's keep this away from the UN. But it has in the background this atmosphere of like, this is something we need to address human rights. It's the Red Cross that has really popularized this term, international humanitarian law. And the Defense Department still wants, our Defense Department still wants to call it the law of war, to keep your eye on, wait, it's about what do you do when you're actually fighting a war. Humanitarian law makes it seem the priority should be on the humanitarian restraints, and it doesn't matter who wins or not. I think that is not really a view that any combatant state can seriously engage if it's a serious war. So there's something a little bit kind of fanciful about it. And just one more element of this. The previous conventions always acknowledged it was binding between the parties, but you weren't bound to observe these rules for a state that didn't subscribe to them. And related to that, if another state had violated the terms, you could impose reprisals in kind, because how else are you going to get them to stop? If you kill some of our prisoners, we're going to kill some of your prisoners. If you attack some of buildings that are supposed to be protected, we're going to do this to you. AP1 says no reprisals against civilians or civilian objects, and no reprisals against prisoners of war or other protected categories. So all of this leads to this notion that there's a kind of Kantian imperative. You must adhere to these rules because these rules are humanitarian, and that is the highest priority. And this maybe looks good if you're in Switzerland and you don't actually care who wins the war around you, but it doesn't actually look good if you're in a state that's engaged in a serious war. So a lot of states didn't ratify AP1. As a matter of fact, most NATO states for 10 years after it was finished said, no, we have too many concerns about this. It was only at the end of the Cold War that NATO states started thinking, okay, we don't have to worry about fighting a war anymore, so yes, we can ratify these things. Britain and France did not ratify until 1990 and 2000, respectively. They waited a really long time to ratify. The United States has been mentioned, is not a party. Israel is not a party. I believe India and Pakistan are still not parties. Turkey is not a party. I mean, there's quite a number of states that think they might be in a war and say, no, thank you, we're not going to ratify this. To get around this, the Red Cross says, well, it doesn't matter because it's customary law. and I just briefly want to focus on this. The traditional idea of customary law was it is what states do from an acknowledged sense of obligation. The Red Cross has produced really extensive, elaborate studies just in the last 20 years to show that really everyone accepts that AP1 is customary law. And it might even be so that everyone accepts at some level of abstraction that that's what they think. But what they don't do at all is to say, states fighting wars actually fight them the way we in the Red Cross think the rules require. And they are often just completely childish and silly in the evidence that they offer up. You can't bomb civilian property. And one of the proofs they give of this is that Neville Chamberlain said this in Parliament in 1939, and they just completely miss, wait, and then what happened after there was the Churchill government? Did they adhere to that rule? We're not interested in that. We got 1 point on the board from someone said this. They quote Saddam Hussein against using chemical and biological weapons. He said that he was opposed to doing it. I mean, actually, he did do it, but never mind, he said it. So this would be an extremely hard thing to pin down exactly what is it that war-fighting states do in practice, and the Red Cross is not trying because they prefer to be moralistic about this. My conclusion from this is not, oh, bah humbug, there is no law. Good luck to Captain Wheatley teaching this to our future officers. Good luck to Captain Herzig giving advice to people in the IDF what they can and cannot do. I understand they have to come up with what they think is a workable rule. But for us on the outside, as observers, you should be extremely skeptical when someone says with great confidence, oh, this is clearly against the law of armed conflict, because the law of armed conflict, as we know it today, there are a lot of disputes about exactly what it means and how it applies, particularly in relation to the conduct of military operations. Killing prisoners of war is really an attacking sites which are mixed use of civilian and military. I mean, there's a lot of reasonable disputes of this, and as my predecessors were saying, it's very, very hard to apply this proportionality formula, and you should be skeptical that anyone serious could imagine that a commander in the midst of serious battle could make a really reliable calculation of the military advantage from one attack. So actually, most signatories say it is not about any one attack. It's about the overall campaign. This is another problem because you're asking for an aggregation of a lot of command decisions. So this is very, very hard to apply. And people on the outside, like most of us, should just be properly cautious and skeptical. That's as much as I wanted to say.
Thank you, Professor Rabkin. It was very interesting. And you actually brought up a point that Captain Herzig touched on, but I wanted you to expand on it because you also read about it in one of your papers that was assigned for this evening, which is, there's such a level of, I'd love if you could expand on the notion of the fact that there's such a level of subjectivity when it comes to determining what constitutes a concrete military advantage. And so when we're, so it may be the case that, Captain Herzog was talking about, when there's one commander killed, the IDF is engaging, a Hamas commander is killed, the IDF is engaging in all sorts of calculations on its end about what that actually means for strategic military advantage. In your mind, could you just talk a little bit about the subjectivity of it and sort of the challenges of defining what constitutes a military advantage, both on the inside and on the outside?
So let me just, this is maybe not responding to your question, but
that's okay. Feel free to discuss what you'd like.
So one of the things that made AP1 very controversial at the time, and was one of the reasons why President Reagan said, no, we're not doing this, we're not signing this, no, was people thought it gave too much protection to guerrilla forces who could be terrorists. Right? The traditional rule is you have to wear a uniform and be under like organized command, and this sort of dispensed with those things. So you could hide among civilians, but still claim to be treated as a POW. If you really think that this applies to guerrilla forces, then you just think about what the rule of proportionality means for a guerrilla attack. You are not actually strong enough to win a head-to-head battle against the opposing army, because that's why you're guerrillas, because you're so weak. So all you can do is try to demoralize them, right? Try to make them feel like, oh, we lost some people. Yeah. What is the concrete and direct military advantage of any attack like that? And the answer is, well, excuse me, it's completely, conjecture about the psychological impact.
Mm.
There's no way, I don't think, to be concrete and direct in your analysis of where, like, what benefit do you get from killing a few people on an outpost and running away? Excuse me. So I don't think they were like real serious. It is something that I didn't mention that is really actually worth mentioning, which is this didn't happen because of loose drafting. The PLO and the African National Congress, which at that time was a terror group in South Africa, they were invited to participate in the drafting conferences. And they were very interested in protection for guerrilla forces. And they were also very interested in constraining Western forces, which they had Israel very much in view in the 1970s. I mean, this is just at the time when the UN has the Zionism is racism resolution. Well, that's when they're drafting this thing, right? I mean, the people are really kind of stirred up about like Israel is a danger to the world. So it isn't surprising that AP1 has the potential to be used against Israel in a way that's like kind of unreasonable, measured by what people used to think was like a reasonable amount of constraint in the conduct of war.
Okay, well, your answer prompted Captain Wheatley also want to say something, so I will turn it over to him. Captain.
I'm sorry to intrude on your time here, but I
No,
actually
it's
was
okay. Please do.
going to mention this, but I cut it out for time. But you brought up the subjectivity in proportionality that goes along with it, and actually the American DoD Law of War Manual has a great comment. It's in a footnote on the topic of proportionality, but it's how one scholar described the subjectivity. It said the proportionality judgment remains an essentially subjective and personal matter. Interviews with practitioners suggest that professional experience and personal morality, rather than a transparent and stable set of criteria, determine what is considered proportionate. Military lawyers acknowledge that as a result, different professionals are likely to come to different conclusions about whether an anticipated collateral damage is excessive in the same situation when applying the law in good faith. And this is the key part here, commanders suggest that proportionality judgments in reality often boil down to asking, can the estimated collateral damage be further reduced through timing, choice of weapons, or angle of attack? And if the answer is no, then the principle of proportionality has been fulfilled. And I mean, in my own experience, I found that to be true. This is what good faith compliance looks like in real life. It's not a highly complex, painstaking, one might even say pedantic analysis with supercomputers. It's a commander saying, have I done everything that I can without sacrificing what is militarily necessary to win the war? And if the answer is yes to that question, then that's pretty much what it means. That if you're a commander, that's what's going on in your mind in most cases.
Well, that was very helpful, actually, that there is a definition out there of what type of factors you actually should be considering, and that it's not there is an element of subjectivity, but that subjectivity is a function of concrete factors. So that is helpful. Professor Rabkin, one last question for you, and then I'm going to open it up to the questions that we've received and try to get through some of them. The last one is, and this relates to some of what you discussed in your paper, but also in your monologue as well. Is there a sense in which AP1 prolongs conflicts or prevents a decisive victor? Like, has it done damage in that sense?
I don't know.
Okay.
I mean, I think that people who are standing on the sidelines, like Human Rights Watch and Amnesty International and the Red Cross, don't care if it does that.
Okay.
Because they're projecting this as like the most important thing is to abide by these rules, which
Right.
I don't know, why is that the most important thing? I mean, particularly if it means prolonging a war, which means you might be prolonging casualties, right?
Suffering. Yes.
The American Army Civil War Manual said um, harsh wars are short and shorter wars are more humane.
Hmm.
I'm not saying that's always correct, but I mean, this is a thought that didn't just occur to you.
Okay. Well, thank you for that answer. It's actually brief but insightful. So I am going to look through some of the questions now. I've been reading them as people have submitted them. So I will do my best to get through a good portion of them. But without further ado, let's see. So, okay. Um, we've answered some of these already. Okay. Okay, so this actually is about, this is probably best for Captain Herzig. Um, so we keep hearing about proportionality, and doesn't that mean you respond to the level of risk and not the number of troops or the size of the bomb? So if Israel is attacked and 1,200 civilians are purposely killed, and Sinwar pledges to uh, eradicate the Jewish people, shouldn't that be taken seriously? So I guess the question, I would summarize this for you, Captain Herzog. To what degree does rhetoric, particularly coming from Israel's enemies, factor into military decision making? Because it seems to me that the threat is quite real, and they have the enemy of Israel are genocidal, and so how does that factor into our discussion of LOAC?
I would separate between the strategic level and the
Mhm.
tactical level, and the proportionality assessment is more one of the tactical level that's done by, you know, commanders on the field and in the decision-making process of targeting or tactical raids or operations, and not as much as when reflecting to what a genocidal maniac said or did not say. I think
Okay,
it that helps.
it does, yes. This is for you, Captain Wheatley. Uh, is there a way in which, so we've been discussing, I think Captain Herzog got into a little bit of this with his discussion of the IDF's decision making, but maybe you could speak to when the United States makes a decision to strike. There are times where you don't have enough time to really confer or engage in the types of analysis that you would want to, because war is fast moving. How do we deal with those fast moving instances when it comes to getting the right legal advice to decide if a strike is appropriate or not under LOAC?
Yeah, that's a great question, and I would say the cornerstone of all law of armed conflict is good faith. I think Professor Rabkin put it aptly that the focus, certainly from the United States' standpoint, is on winning the war. That's why it's called the law of war, not international humanitarian law. And so, if the realities of armed conflict or a battle, shall we say, prevents the sort of highly detailed, nuanced analysis that in an ideal situation would be required, then a commander is going to do what's best to secure victory. And that's not something that's just my opinion. That's something that's reflected at the highest echelons in our military. We have, as I mentioned, we have this great thing called CHIMRAP now that's supposed to really assist our commanders in minimizing civilian harm. But to the extent that it exceeds LOAC's requirements, it may be suspended in times of really, really extreme necessity, such as, like an Indo-Pacific outbreak of war where commands are dispersed, right? Lawyers are 1,000 miles away, and commanders have to rely on just the basics of what they know to make decisions. So that's a long-winded way of saying the answer just really relies on good faith compliance.
Understood. Captain Herzog, did you want to add anything to that or no? Okay, thank you. Um, this is a question about, I guess this would be a question for both Captain Wheatley and Captain Herzog. Are there any strategies that you are able, if you're able to answer the question, I always preface it with that, given the positions you're both in. Is there any advice that you've found that soldiers have received with regards to determining who's an enemy combatant and who's a civilian. I know that's particularly difficult when it comes to urban warfare because a lot of times the combatants, terrorists, will dress as civilians. So are the soldiers well prepared to kind of make those identifications or those distinctions?
I'd say that all soldiers need to come. The starting point is that everyone's a civilian unless,
Hmm.
and what the unless is very circumstantial. Um, Usually it's quite easy because he will wear civilian clothes, but he will shoot at you with his AK, or you will see him booby trapping a house, or coming out of a house that your intel says that it's like a Hamas house, not a private home, but like actually command and control center, perhaps. Um, and that's for like the real-time decision making. If you have more time, then perhaps you can gather intel and then you do the whole identification process of whether he is a part of an OAG, an organized armed group. The intel can says he's a Hamas operative, yes or no. Or if he's not part of Hamas, you can perhaps independently point at this person because of his conduct as a direct participant in hostilities. But then again, you would need the intel to say that.
Okay, thank you. Captain Wheatley, did you want to chime in on this?
Yeah, what we have basically reflects the same model. I mean, we have the international armed conflict model, which basically says, hey, uniformed adversary, they're targetable, even if they're like just sipping coffee and hanging out, right? They don't have to raise a rifle and point it at you. In more non-international armed conflicts, or perhaps if you're dealing with a non-state armed group embedded in a civilian population, we go by hostile act or hostile intent, and that phrase is very much ubiquitous in our rules of engagement, depending on what the campaign is. Every soldier is going to know that as they're about to deploy because they receive briefings on this. And so I would just add that's chiefly ours as well as hostile act, hostile intent. For things like what the ICRC would call a continuous combat function, or what are the limits of direct participation in hostilities? You get into those gray areas. Generally, those are not decisions that are really pushed down to the lowest tactical level, right? Especially if you're dealing with deliberate targeting cycles. Those are things that are decided much higher up.
Okay, understood. Professor Rabkin, I had a question for you. Is is there a degree to which so there's a lot of commentary that comes out of these humanitarian law organizations, and I use the word humanitarian lightly, but there's a lot of commentary that comes out of these organizations, and it's almost sort of been absorbed in a way, it's been absorbed into LOAC and created sort of a new version of LOAC. I wonder if you could comment on how it's sort of reminiscent of customary international law? Because you have mentioned customary international law a few times this evening, but I think there's an analogy there. It's almost like if you say it enough, it becomes true. And
Yes,
so Professor
yes,
Wheatley was talking about the risks of
yes.
that being the case. So I'd love to hear your comments on that.
Yeah, so actually, one of the absurd um, features of the Red Cross study on customary international humanitarian law is after they get through citing completely inapposite, foreign leaders from the wrong period and all that, then they get to, well, Amnesty International said this, and Human Rights Watch said this, and actually we've said this, and they just gloss over. What are you talking about? You're not states. This doesn't matter at all. This is just happy talk. Why are you citing this? And the answer is it contributes to the atmosphere of like everyone thinks this. We should also remind ourselves, excuse me, um, I would sum up my main point in one quick sentence.
Take your time.
The law of armed conflict is not like tax law. Why is tax law so precise and well known? Well, among other reasons, because we have hundreds, and over time actually have many hundreds of court decisions which clarify really small niggling points of detail because people have been able to bring it to a court which had authority to decide. There are I believe no, that is zero cases from international criminal tribunals saying, oh, no, that was disproportionate. And they just haven't wanted to go there. There was the tribunal for the former Yugoslavia. There's the tribunal for Rwanda. I guess it didn't get that much into fighting aspects, but the International Criminal Court. The prosecutors are just like, oh, this is like, you know, blah, blah. And to my knowledge, there's not a repertoire of cases from national military courts.
Okay.
You guys can correct me, but Captain Wheatley, is there one case like this from American, you know, military court of appeals?
No, not on the question of proportionality. If
Oh, that's
anything, it's
right.
been
That's
charged
right.
under.
Thank you. That's enough. I mean, just on the point of proportionality, right? This is so slippery that prosecutors don't feel that they can make a compelling case, right? So that tells you we're not really sure what this is because we don't have a whole bunch of court decisions saying, oh, yeah, it's clearly this, clearly this, it's clearly this. That's even for ourselves.
Right.
I think if there were international decisions, we wouldn't necessarily embrace them, but at least we would have a better sense of the kind of, you know, some kind of baseline. In the absence of that, these organizations can just say whatever they want to say. It's like what seems right to them. And if you are mainstream media, you just put a microphone in front of their face and then they start talking.
Or if you're Ireland, you rewrite the
Oh, fine,
definition.
fine, fine. And then, yeah, so they all love
Yes.
to say that. So they
Yes.
all
So
love,
yeah, go ahead.
yeah, they all love to say those things. What this see what I think this is like is and I'm old enough to have, you know, experienced this. Law professors work themselves up into like clearly this is unconstitutional. I give you a famous case. The United States Congress said if you don't allow military recruiters onto your campus, you will forfeit federal funds. And the dean of the Harvard Law School, I won't mention her name, but she became a Supreme Court justice afterwards, said that's clearly unconstitutional. And the deans of, you know, Yale and Penn and Chicago, those, was clearly. When it actually got to the Supreme Court, it was 9-0 in favor of no, actually, it is constitutional. But imagine you don't have the Supreme Court and you just have these, you know, law professors who are spinning out there like my theory of the universe, this should not be allowed. That's, I think, a pretty good analogy to what's happening when Amnesty International and Human Rights Watch and even the Red Cross start telling you, this is how we envision the law of armed conflict, which is actually not extremely helpful because it's not really your job, even the Red Cross, to like lay down authoritative standards. And you clearly have an agenda.
And do you think that there's a risk now with these types of organizations or even law professors pontificating on these issues, and then they are sort of, those opinions are scooped up by nation states, right? So we're starting to see a bit of a reciprocal or a trickle into relationship with regards to Ireland.
It's scooped up by nation states like Ireland, which, you know, its most important war was a series of terror attacks in the early 1920s, right? I mean, it has not participated in any major war since 1921, if you want to consider their terror attacks as a war. So it's not actually interesting what Ireland thinks. They're not putting their own troops in danger because they don't send their troops to war zones. So they don't even contribute to peacekeeping missions, right? They're just talking. And this is true also of Portugal, right? We just go down the list. Who's actually saying this? Germany, I think not just because it like feels a little bit squeamish about its own history. I think they like actually might have troops in combat. Britain, France, they're more cautious. The United States is way, way more cautious because we actually do have troops in combat. So there's something, this is again, like practice can't just be what everyone says. It's like saying, you know, we're going to establish rules of naval warfare and we're going to consult 100 countries that don't have navies. Just raise their hand and say, well, we think the rules ought to be this. This is actually not relevant. And it surely cannot establish a custom just because they said it.
And that's a resounding critique of customary international law, but yes.
Customary international law works well for things extremely
are practiced.
Pervasive, like the historic thing was the immunities of ambassadors.
Yes.
Almost every state is receiving ambassadors and sending ambassadors, and they get into disputes about their immunities. So you've got lots and lots of practice there, right? And almost everybody is contributing to that practice because almost everyone is receiving and sending ambassadors. Not everyone is fighting wars. And in particular, they're not fighting modern wars with advanced weaponry. Right.
Understood.
So it's very dangerous to extrapolate from what the bystanders say.
Understood. I think that's exactly what Captain Wheatley and Captain Herzig said too. And this is actually a question for both Captain Wheatley and Captain Herzig. Are you able, to the extent you're able, to discuss the use of AI and how that enables more precise targeting in either the US or Israeli military? So, Captain Wheatley, we could start with you.
Well, I can't really discuss how AI is used or not used
Yes.
in the U.S. military, but I will talk about Elon Musk for a second on
Okay,
this
please
exact
do.
question and how this can affect um, uh, how we apply the law of armed conflict. He was actually here. Elon Musk was actually here at West Point giving a talk to our cadets during our fall convocation, and he talked about how. With the proliferation of AI, the war is going to move much, much, much faster. And so fast, in fact, that even simply being a human on the battlefield won't just be ineffective, it'll actually be a liability. And that raises some really, really important questions about how does a commander factor that when a computer when an adversary's computer rather can make a decision in nanoseconds, can assess massive amounts of information and can project possible courses of action and pick the best one all before the commander has actually even like had a chance to blink, right? That's going to affect how we conduct our proportionality analysis and apply LOAC otherwise. So I hope that's a satisfying answer. I couldn't really answer your first question, but anyways.
No, it's interesting. I mean, I think the evolution of AI more generally, it's a disruptive force, and it can be a disruptive force for, disruptive can have both positive and negative connotations. So I think that in terms of, targeting, I'm sure it offers a lot of different prospects, but it also can make things more deadly too. And so I actually have, so Captain Herzog, I don't know to the extent you're able to speak about AI more generally, but if you're
Mhm.
not, please feel free to decline to.
It's fine. I think the origin of the question is because two tools used by the IDF gained some media attention. One was called Habsora, the Gospel in English, and the other one's called Lavender. Um, Media reports said that these are, you know, uh, like AI systems that identify and decide which targets to strike, and I think this is a good platform to say that this is untrue. We do have tools that help intelligence analysts cross-examine and cross-reference different informations that we already gathered from our intel sources. And these AI tools, like in every, I know, company, in like a civic company, just helps to make processes more efficient. Every decision is a human-based decision in the IDF. There's always a human intelligence officer and analyst that approves and looks, and there are levels of approval. So merely tools of, making things more efficient in the process of working. And there was actually a IDF press release about it in reaction to the media coverage that I can send the link to, which gives a bit more detail.
Okay, excellent. Well, this is a final question for the panel before we wrap up because I know that it's been a long evening, but a really interesting one. So I'm grateful for everyone's contributions, and especially Captain Herzog, you get the award for being up the latest. Um,
It's almost morning now, so
okay, well now you can start. Now you can have a cup of coffee and start your.
yeah.
So the final question, I guess, and this is sort of gets to some, you sort of answered it in the panel, but I also wanted to get back to the purpose of the panel. And Captain Wheatley, you touched on it at the end of your monologue, which is under the current interpretation of LOAC, as understood as not properly understood, but how people have come to understand it erroneously. Is it possible to actually win a war decisively? I'll give you each like a minute and then we'll wrap up.
My first.
Yes, you're first. You're up.
Yeah, sorry. Okay. Yes, it's possible to win a war decisively, but you have to be on guard against distortions of LOAC. And that means certainly as a reader, right, or as someone who just exists, perhaps you're not in the military, you're a lawyer, you're a practitioner, maybe you don't even practice international law of any kind. Um, you have to have some basic rules to challenge what you're reading, right? So anytime Amnesty International or Human Rights Watch pushes out some dumb report, sensationalized article, making massive, bold accusations against Israel, the United States, whatever it is, have the toolkit to challenge that narrative, and that means knowing what the law actually says and what sources to consult. So yes, totally possible to win a war while complying with LOAC. Less feasible if it's a distortion of LOAC or fake LOAC.
Okay, thank you. Captain Herzig.
Sorry, I was muted. I completely agree with Captain Wheatley, and I believe, as I concluded in my opening statement, that according to the law as it is today, I think there is no military objective on the battlefield that IHL prevents a reasonable commander from achieving, even if there are some legal constraints. The problem is perhaps public opinion, because that's really what the distortion of LOAC causes. But on the battlefield, definitely can have a decisive win.
Thank you, Captain Herzog. And last but not least, Professor Rabkin.
I defer to the military people.
Okay, well, thank you. Once again, this was excellent presentation by you all. If our listeners would like to get in touch with you, is there a means by which they may be able to do so, or if they can follow your work somewhere? Feel free to share. We can start with you, Captain Wheatley.
Yeah, so if you go to West Point's website, you could just Google my name, Thomas Wheatley, West Point. It's like the first result. It'll have my email in there. Would love to hear from you. You can also check out Articles of War. I'm an editor over there. Feel free to reach out at that email and we'll get a response to you.
Great. And Captain Herzog, is there a way that folks can
Follow
follow
the
you?
news, and that's how you follow my work.
Okay, thank you. And Professor Rabkin.
This is going to sound so professorial, but if you go to, what's it called? Social Science Research Network, SSRN.
Okay.
My articles are posted there.
Wonderful. Okay, well, thank you all for your time, gentlemen. I hope you all have a great evening. Thank you for making us smarter people at the end of the session.
Thank you for hosting.
And thank you all for your service. Thanks.